he may have gone there and said, "I have sympathy for the family." That's the bare minimum you can do. Yeah. As a human being, that's the bare minimum. What really shows remorse is when you say, "I regret what I did. If I could do it over again, I wouldn't have done it. I feel terrible for Chad, and this is something I have to live with for the rest of my life." That would show some remorse. He didn't say that. He was out there saying that he's the victim, really, that this guy was big. He thought it was the end of the line for him. He was the one trying to get out of jail pre-trial, didn't want to accept any responsibility. He tried to get this case dismissed before it ever got to a jury through stand your ground. So I don't have any sympathy for him. He got away with it, even though he did have to face some repercussions. It wasn't totally scot-free.
Curtis Reeves Jr. He led a life of service. He is a United States Navy veteran and a former Tampa police captain. In fact, he helped launch and lead the agency's first SWAT team before he retired in 1993. He later went on to work for Busch Gardens as director of security, and he was an active member of his neighborhood Mountain View Estates Crime Stoppers organization in Brooksville's Spring Lake community. Now, this was right outside of Tampa, Florida, where he lived with his wife, Vivian. He and his wife, Vivian, had been married for years and, in fact, had 3 adult children, a daughter and 2 sons, one of whom was a Tampa police officer himself. So, what caused this 71-year-old gentleman who led a life of service to kill a man while he was on a movie date? The sin gluttony, defined as eating or drinking to excess beyond reason, greedy, or excessive indulgence. This is the why behind the crime, the motive. I'm Ashely Willcott. I'm a TV anchor, a former judge, a former trial attorney, and I would say that almost all of the cases that I have covered over the years intersect with one of the 7 deadly sins: pride, greed, wrath, envy, lust, gluttony, and sloth. The opposite of the 7 heavenly virtues. Temptations that, taken too far, turn deadly. This week, we break down the case of Curtis Reeves Jr. and how the deadly sin of gluttony may have caused him to shoot and kill. Was it in self-defense? A little later, I am joined by Dave Aronberg, a former prosecutor, in our breakdown segment, where we do a deep dive on the how and the why of a 21st century true crime. We know he did it, but was it self-defense made for the big screen? Let's get into it. This is the Deadly 7. On January 13th of 2014, Curtis and Vivian Reeves planned a date. A middle-of-the-day date for the retired active couple to see a matinee showing of Lone Survivor at the Grove 16 Theater located in Wesley Chapel, Florida, near Tampa. Also on a date to see the very same movie at the same time in the same movie theater, Nicole and Chad Oulson. Chad Oulson was a 43-year-old father who worked at an ATV and personal watercraft dealership. He, too, led a life of service. He was a retired American Gulf War veteran. He worked a Tuesday to Saturday schedule at his job, so his wife, Nicole, had taken the day off so that she could go on a date with her husband. Chad and Nicole Oulson had a 3-year-old daughter, so they dropped her off at daycare as they headed to the movie. The Oulsons got their snacks and popcorn and arrived at their seats. Curtis and Vivian Reeves came in after the Oulsons into the movie theater and chose seats in the row behind the young couple. The previews began, and Chad Oulson begins to text on his cell phone his daughter's daycare. Reeves speaks up about not texting in the movie theater. The movie started, and the 2 men begin to argue. As tensions mount, Chad throws his popcorn in Curtis's face, and Reeves, retired law enforcement, reaches for his gun. He fires a shot and fatally shoots Oulson in the chest. Reeves is arrested, and he is charged with aggravated battery with a deadly weapon and second-degree murder. The very next day, he's in jail, and he makes his first court appearance with his defense attorney, Richard Escobar. Richard Escobar argues that his client acted in self-defense and shouldn't be considered a flight risk or a danger to the public. Remember, at this time, Curtis Reeves is 71 years old. After a very short hearing, though, Circuit Judge Lynn Tepper orders that Reeves be held in the Land O'Lakes jail without the possibility of parole as he awaits trial. About 3 weeks later, as good defense attorneys do, the defense attorney tried again. There was a 2-day bond hearing with more than 12 hours of testimony. But Curtis Reeves was denied bond a second time. Again, a good defense attorney. The attorney appealed to the 2nd District Court of Appeals. On July 12th of 2014, after 7 months in jail, Reeves is released on bond, $150,000, because he won his appeal. The conditions of his release on house arrest require him to wear a standard ankle monitor for GPS tracking at all times, allowing only for him to go to the grocery store, his attorney's office, religious services, and medical treatment. Reeves is also ordered to surrender all of his firearms to the Pasco Sheriff's Office. Fast forward now to November 6th of 2015. Reeves and his attorney Escobar file a motion to dismiss the criminal charges. They lay out a self-defense argument under Florida's Stand Your Ground law, a controversial law. A Stand Your Ground hearing was held to determine if Reeves should be immune from prosecution or if he should instead be tried before a jury on second-degree murder charges. The law in Florida at the time says a person has no duty to retreat when faced with a violent confrontation and can then use deadly force if he or she fears death or great bodily harm. They held a 2-week Stand Your Ground hearing. After that hearing, the Circuit Judge Barthel issues an order denying Reeves's request for immunity from prosecution under the Florida law. The defense filed an appeal. But the 2nd District Court of Appeals denies the request for immunity. It means retired Tampa Police Captain Curtis Reeves Jr. one step closer to a murder trial. There was some legal maneuvering, and Curtis Reeves and his attorney tried to challenge the Stand Your Ground and say there's a new burden of proof that's on the prosecution that should apply. The Florida Supreme Court ruled that no, the burden shifting under the new law from the defendant to the prosecution for the burden of proof is not retroactive. The case means that Reeves, who's now 76 years old, is once again set to stand trial for murder. His attorneys request a court date, and the trial is scheduled to begin in January of 2021. But coronavirus pandemic spreads across the state. The case of Curtis Reeves Jr. is delayed. But at last, 8 years after the shooting death, trial begins. Testimony lasts 9 days during the trial. The wife of the victim testifies. The wife of Curtis Reeves Jr. testifies. Curtis Reeves Jr. himself takes the stand to say, I shot in self-defense. I was in fear for my life. 9 days of testimony. Compelling closing arguments. Here is what the state prosecutor said during the closing argument. Nobody is ever above the law. Reeves killed another human being in a crowded movie theater next to his wife for no reason. The defense then had an opportunity to make their closing argument. Starting over. The defense then had an opportunity to make a closing argument. This is what the defense argued. Jury, put yourselves in Reeves' shoes at the time of the incident. He was 71 years old, and the perceived threat that he believed existed. He described Reeves as a decorated law enforcement officer who had countless hours of training in the use of force and the assessment of danger and the risks that take place when we are faced with a dangerous encounter. The jury began deliberating on a Friday evening, and late that night, after 3 hours of deliberating, the jury returned a verdict of not guilty. Curtis Reeves was acquitted for the alleged murder of Chad Oulson. Joining me now, I have Dave Aronberg, attorney extraordinaire, the former state attorney for Palm Beach County, the managing partner currently of Dave Aronberg Law Firm, and very excited for you, the host of Court Authorities on YouTube. Dave, you're brilliant. I always love having you on. I want to make a few comments about this case because I connected Curtis Reeves Jr. to the deadly sin of gluttony. And some people may say, why? Because they were eating popcorn and he wanted to eat too much? No, because I really thought of him as a greedy Gus. And here's the reason. Interestingly, greedy Gus is also called greedy gut, which I'd never heard of, but they are both used. But a greedy Gus, I thought of it for him because I just wondered, was he wanting more than was needed in this case by shooting and killing the man that he got in an argument about texting in a movie theater? Um, was there no thought for the needs of others, not just the man that he shot, but the wife, the 3-year-old child, daughter that they had together? Was he selfish, excessively eager? I mean, look at the number of times that he and his attorney appealed, first of all, getting bail. They appealed it more than once. They had more than one hearing on that. Eventually, he did get out on bail. And then the number of times that he argued self-defense and had the stand your ground hearing, he lost that, but he continued at trial to argue self-defense. So I just wonder, is greed something that motivated him to commit the crime, but also then to proceed through the criminal justice system? So let me turn it over to you and start with your thoughts on greed before we really do that deep dive also into stand your ground in Florida.
Judge Ashely, good to be with you. I guess greed comes in different forms, like you're thinking that you're better than everyone else, you're above the law. You don't have to comply with the rule of the movie theater that you're not allowed to bring guns in the theater. He didn't care. He's a former cop. He'll do whatever he wants to do in his mind. He brought a gun in, not allowed. And when a guy got into an argument with him, and by the way, it was Reeves who started the argument. It was Reeves who was the initial aggressor, who started jawing at the guy because he was checking his cell phone. And mind you, this is before the movie even started, okay? So Reeves had to be a Budinsky, that's a technical legal term, and had to butt into other people's, right? Yeah, he had to be a Budinsky and butt into other people's private lives and say, turn that off. Meanwhile, he's checking the phone. The guy's checking the phone because of a babysitter issue. And then they jaw and it gets heated and the victim throws popcorn at him. Now, I was there in the legislature when Stand Your Ground was first passed and was never thought to apply in a case where instead of facing a gun, instead of facing a knife, you're facing some popcorn being thrown at you. And so Curtis Reeves took advantage of the law. He thought he was above the law. And in the end, he got away with it. So, yeah, not a great showing for the state of Florida.
he got away with it. I mean, I was incredulous. We all were. Who are we kidding? Because we all watched this unfold. Now, there is a video, and this is a case where that video was played over and over and over again for everyone who was watching the trial. And you do see the throwing of the popcorn, and he did describe that as he saw a flash. He was in fear for his life. But we go back to the basic premise that number one, you shouldn't have a gun in a movie theater. Number two, at the end of the day, he shot and killed someone for checking a text during a preview. You just summed it up. How did you react when you heard the jury acquitted him after about 3 hours of deliberating?
I was disappointed, but I wasn't totally surprised
Mhm.
because first you had an older defendant and he has law enforcement in his background. And so there's a willingness to try to give him the benefit of the doubt. Also, I'm sure the jurors thought, what good is it to put a guy like that in prison? So in the end, I wasn't that surprised with it. Also, if you slow down the video, and defense is really good at that, instead of all this being one incident, you slow it down and you start to perhaps see this as more menacing than it is. This has all happened really fast. Most of us would never have reacted this way. But when you slow it down, then you try to put the jury in Curtis Reeves's position in through his eyes, and
Mhm.
maybe all it takes is one to say, "Yeah, right there, the guy's standing over me, and he's menacing, and he threw popcorn at me. I could see it through his eyes." If you do it all at once, it's like, "No, what just happened? Why would he escalate this thing, to this extent?" And so that benefits. You know when they also did that where it worked? It was in the Rodney King case. Many years ago,
Ah.
Judge Ashely, the defense lawyers slowed it down frame by frame by frame to show, look, he's still moving. He's still a threat on the ground, even though when you play the video in total, it's like, what just happened here? So it's a technique used by the defense, and it worked here.
And you're so right because we know, and I say all the time, a video is some of the best evidence you can have. Pictures are some of the best evidence you can have. But when you take a video and you do slow it down, it's why that is something that movies use in Hollywood to change the feel, to change
Right.
your perception, right? To
Right.
slow
Exactly.
it
Exactly.
down. And you're right, it does accomplish that. But one of the things that I think that in this case really stands out to me is to juxtapose our criminal justice system from a jury and the jury's decision because 2 judges said no bail, and then on the appeal, he won and he got out on
Mhm.
bail, and then stand your ground, a judge heard a lot of testimony for many hours and then said, "No, this is not a stand your ground case."
Right.
But
Right.
obviously, the jury agreed with Curtis Reeves, who testified himself and said, "Well, he did it in self-defense, so we're going to acquit him." But tell us a little bit because stand your ground law in Florida is controversial, and people all over the nation who practice law have talked about it and the burden change. Tell us a little bit more about that law.
Well, stand your ground was supposed to ensure that you do not have to retreat if someone is threatening you. So there was some jury instruction in the past that made it so that you had a duty to retreat if someone comes at you. Even in your own home, there's the castle doctrine that says your home is your castle, but there's some ambiguity back then. And so legislature passed a law that said, no, if you have a right to be somewhere, you can meet force with force. But it never envisioned that you could meet a popcorn thrower with a gun,
Yeah.
and that's where it is now. It's gotten morphed into something different. Now, the legislature revisited Stand Your Ground, and instead of making it better for law enforcement, they made it better for the defendant by putting the burden of proof onto the prosecution to prove by clear and convincing evidence that the individual, the defendant, was not in reasonable fear of his or her life. So that's something where the legislature keeps moving in the direction of giving the defendant the benefit of the doubt. So what happened was the law changed in the middle of this whole thing with Curtis Reeves. And so Curtis Reeves went back and said to the judge, Your Honor, now the law has changed. We want the new law that says the burden is on the prosecution to prove that Curtis Reeves was not in reasonable fear of his life, and they've got to prove it with clear and convincing evidence. And this went all the way to the Florida Supreme Court. The Florida Supreme Court said, no, 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 no. It's not retroactive. You have the law at the point of the incident, which was not as favorable to the defendant. And so he lost and lost again. Now, one thing about stand your ground hearings is that if a judge rules that you were in reasonable fear of your life, then it's over. The case is over. It doesn't go to a jury. So judges have shown to be reluctant to take the case out of the jury's hands. And that's what happened here. The judges said, no, no, you're going to face a jury. We're not going to stop this case before it begins.
Yeah, let the people decide. And that, as a judge, you have to make really hard decisions. I was a judge, and you have to be willing to stand by your decisions. You have to know people are
Right.
going to appeal your decisions. So it's a heavy burden, but it's always interesting to me when a judge says no, it's not stand your ground, and a jury basically comes back and disagrees. But that's our criminal justice system, for the jury to hear the evidence and decide. My opinion is always that the credibility of witnesses obviously makes a difference in a trial. But in this particular trial, boy, was it interesting to hear the different witnesses and then see who obviously the jury decided to agree with. And I want to talk a little bit about some of the witness testimony, because Nicole Oulson, 41 years old, her husband Chad was 43 when he was shot and killed by Curtis Reeves, and she testified. And some of the words she used when she testified, I think if you believed her, would perhaps dissuade you from acquitting Curtis. But she described him as, for instance, rude, angry, and demanding when he first confronted Chad about using the cell phone. So that to me makes it sound like Curtis Reeves is the aggressor. And then she said that he kept nagging, was the word she used in her testimony, Chad, but it was enough so that her husband stood up and turned around to confront the defendant, now acquitted, the innocent man, that she put a hand on her husband to stop a potential fight. And she says, as she put her hand, Dave, on him, the bullet fired from Reeves' pistol. And that was it. And if you believe that version of what she tells, it's really hard to imagine that he was in fear for his life.
Totally agree. I was very upset with the verdict, although again, I wasn't totally surprised. Curtis Reeves was the initial aggressor. He was the hothead. He was the one who was making something big out of something small. Now, none of us likes when someone is texting during a movie, but the movie hadn't begun yet. And you had Curtis Reeves, who thinks he's the boss of everyone, John at this guy, and then wouldn't let it go and just kept being the instigator. And you had the victim here who apparently, he wasn't going to let it go either. He could have moved himself. He could have ended it. But it's tough when you have some guy behind you who is butting into your privacy, into your family, and you're just going to respond. Now, didn't have to throw the popcorn. That escalated it, but it didn't escalate enough in my mind to justify using deadly force. But the jury was sympathetic towards the person who was in the courtroom, whereas Oulson, the victim, was not in the courtroom. Yes, his wife was there, but the victim himself wasn't there to defend himself. He was dead. But the defendant, Reeves, took the stand. Here you have an older guy who seemed remorseful. And when you only hear one of the two individuals testify in front of you, oftentimes they'll feel sympathetic towards the person who actually is there in the flesh.
It was interesting to me when Curtis Reeves testified, and I was watching and covering this trial, that he was very calm and
Uh-huh.
composed when he testified, Dave. He wasn't crying. I mean, come on, even if it's self-defense, you've shot and killed someone. Even if you have training as law enforcement and you have shot and killed people in your role as law enforcement to protect and serve, still I would think that you would dissolve in being upset. Testifying, he was very calm and composed. And he said, and this is a quote from his testimony, I was concerned that he was so much above me, full of rage. I think you can say that he was going to strike me with all the strength. I figured that this was the end of the line for me. I noticed he was standing up, Reeves testified. He was yelling a lot of profanities, threats. Who the fuck do you think you are? I was texting my fucking daughter. The F word seemed to be his primary vocabulary at that point, Reeves said. Now, Reeves did go alert a manager at the theater, and then he came back to his seat, and that's when things escalated. But what's fascinating to me is not just what he told, but the way in which he told it would give me pause to think he had any remorse for what happened, Dave.
Well, I don't think he had any remorse. I think to this day he still thinks he's justified,
Wow.
and he went to court in that mindset, and the jurors took his side, his point of view. I wonder if he was, 25 years old instead of his age. I forgot how old he is, but he looks older, and I think he got sympathy for it. And, I don't know the composition of the jury, but you may have had retirees there that put themselves in his shoes, seeing this young, big guy stand up and throw popcorn at him. And they probably thought, oh, if that happened to me, who knows? Maybe I'd do the same thing. So I don't think Curtis Reeves had remorse. I think that he felt like he was victimized from the beginning. After all, he did spend several months in jail waiting trial. He had to pay lots of money out of his own pocket, pay for legal defense, and it has uprooted his life. I'm sure he's facing a massive civil lawsuit from the victim's family. So he didn't get away scot-free, but he did get away.
And it was pending for 8 years, a small amount, I think maybe 7 months he was in jail. The rest, he had restrictions on his house arrest. I think some people argue he did have that 8 years of restrictions. There was a civil lawsuit, and I can tell you it was settled. The family of Chad did settle that, so that's a financial piece, a financial burden, and when you say, "I don't think he was remorseful," sometimes when I look at and I can tell you, every time there's a motive connected to one of the deadly 7 sins, it just becomes deadly, it turns deadly, but it doesn't mean, even though it's a deadly sin, it doesn't mean people are remorseful about it. It
Right.
doesn't mean that this greedy gut had any empathy or sympathy for Chad, the victim. I think that he was interviewed and said, "Well, I felt bad for the family," but that's not the same thing to me, and so
Right.
it really right? I mean, it's really unfathomable, but I'm sure you saw it, especially as a former prosecutor, day in and day out that, okay, they're greedy or wrath. They're such an angry person or using so many substances that it causes them to be angry, but it doesn't necessarily mean they have any remorse when they're sitting at the defense table in a court before a jury.
Exactly, and he may have gone there and said, "I have sympathy for the family." That's the bare minimum you can do. Yeah, as a human being, that's the bare minimum. What really shows remorse is when you say, "I regret what I did. If I could do it over again, I wouldn't have done it. I feel terrible for Chad, and this is something I have to live with for the rest of my life." That would show some remorse. He didn't say that. He was out there saying that he's the victim, really, that this guy was big. He thought it was the end of the line for him. He was the one trying to get out of jail pre-trial, didn't want to accept any responsibility. He tried to get this case dismissed before it ever got to a jury through stand your ground. So I don't have any sympathy for him. He got away with it, even though he did have to face some repercussions. It wasn't totally scot-free, but that was a real blemish on Florida's eye, that we had this incident happen and you had a guy go free as a result of it.
How do you reconcile or handle or move past if a jury comes up with a verdict that you don't believe is the right verdict based on the evidence presented?
Well, as a prosecutor, you can't do much. As a defense lawyer, you can appeal it. That's another part of the system where it's harder to be a prosecutor, because if you lose a court, there's double jeopardy that attaches under the Fifth Amendment to the Constitution, and you cannot retry the case. If you lose as a defense lawyer, you can appeal and appeal and appeal. So the system is designed that we'd rather have 100 guilty people go free than to convict one innocent person. And I think this is an example of it, where a guilty person went free because we err on the side of protecting the defendant's rights. In the U.S. Constitution, Ashely, there's a lot said about suspects and defendants. You've got the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment. Not one word about victims. Not one word about victims of crime. State constitutions have put in some protections for victims, but not the federal constitution. So how do you deal with it? You just recognize it's part of the job. And in some cases, you believe that you'll see the person again. When O.J. Simpson got away with murder, we saw him again, and he was incarcerated probably longer than he would have been otherwise in the armed robbery case in Vegas. But you see that with a lot of these defendants. Well, Curtis Reeves, I doubt we'll see him again. He's never really been in trouble with the law before. So I suspect that he's someone who will slip through the cracks.
But karma, Dave, I will say this. Every time I've ever done something I know I shouldn't, even as a kid, if I would lie
No,
when you're not supposed to lie and you don't think it's a big deal because of what you lied about, you didn't want to get in trouble, it always bit me in my ass. I mean, it just does. So I do believe
it's
at
true.
the end of the
True.
day, there is some karma that also comes back around. Dave Aronberg, you're amazing. I want everyone to remind everyone, host of Court Authorities on YouTube. Please check it out. Thank you so much for this great discussion on Curtis Reeves Jr., his acquittal, and the greed that I think made him do it.
Thank you, Judge Ashley.
Always.